On behalf of faculty, staff, and students, I want to welcome you to this fourth annual conference on IP in the Supreme Court. Certainly the Supreme Court is taking IP more seriously than it has in the past. I think it's finally recognizing the critical role IP is playing in our whole economy and, of course, in the courts as well. Courts, as you know, has already taken 2 cases for the term, and my guess is that they'll take more. And that's really a recognition, again, of how important intangible property is to our entire economy and indeed that of the world itself. I really want to thank the sponsors, Morgan Lewis, luncheon sponsor, and also session sponsors, Banner and Wickoff, Seyfarth, and McAndrews, the coffee break sponsors, Hush Blackwell, McDonald Bonin, and of course our own iSCOTUS for giving you snippets from the Supreme Court arguments as you walked in, for providing this forum so that practitioners, professors, and indeed litigants can get together to talk about the cases, think together about what the future directions for IP and the Supreme Court will be. It's my pleasure now to introduce Ed Lee, who is the director of our IP group here at the school, whose idea this was and who's engineered it, and I know all of you have come to recognize and appreciate his endeavors. Ed.
Okay, great. Thank you all for coming. Start out the 4th annual Supreme Court IP Review, or SCIPR. This year we've been lucky that the Supreme Court has obliged us with 6 cases, 4 in the patent realm, 1 in copyright, and 1 in trademark. And for those who are Supreme Court aficionados, if you look at some of the cases, it's an interesting breakdown. There are 4 unanimous decisions, 9-0 decisions. And there were 2, the other 2 were majority decisions with 3 dissenters, both. And it turned out Justice Breyer wrote both opinions in those cases where there were majority decisions. And if you want to know who wrote those other opinions, Chief Justice Roberts wrote 2 of the opinions. Justice Thomas wrote probably the most significant decision in Myriad, and Justice Kagan wrote the other opinion in Bowman. Now, this year we are delighted to welcome, for the first time, parties from 2 of the cases argued this past term. Dr. Harry Osterer, who challenged Myriad Genetics' patents on isolated genes related to breast cancer detection. And we'll hear more about that in the panel coming up this afternoon. We also welcome Mr. Vernon Hugh Bowman, a farmer from Indiana, who took on Monsanto in a dispute over the principle of exhaustion as applied to genetically modified soybeans. Also, we're looking forward to a keynote address by Judge Diane Wood of the 7th Circuit this afternoon. Now, earlier this year, we hosted a PatCon conference with a debate between Judge Posner of the 7th Circuit and Professor Richard Epstein of the University of Chicago on whether the patent system is broken. And I didn't think that we could actually top that debate, but I think we have. Judge Wood's keynote will be on, is it time to abolish the Federal Circuit's exclusive jurisdiction in patent cases? So it's a very provocative talk that I'm sure will be an excellent one. Okay, now, I think the best thing for me to do is get out of the way quickly so we can get to the full lineup that we have for today. Before I do, I wanted to mention briefly one housekeeping matter. For those of you who want wireless access, the information is on page Roman numeral 5 of your handout, this handout right here. And also on the cover of this handout, you'll see that there's a hashtag for people who are on Twitter. If you want to live tweet this, and I'm Mark Lemley, I'm counting on you. Hashtag is SCIPR13. So without further ado, I will introduce the moderator for our first panel on the Gunn versus Minton case. Professor Christi Guerrini is the Intellectual Property Fellow right here at Chicago-Kent College of Law. She studied at the University of Virginia, and she received highest honors there and was an Eccles Scholar. She then went on to Harvard Law School and eventually practiced at Kirkland & Ellis in Chicago in patent law and other fields. And she's taught at several different institutions before coming to Chicago-Kent. Christi, take it away.
Okay, thank you. It is my pleasure to introduce the 2 panelists here sitting next to me, Jane Webre and Ronald Mallen, both of whom were personally involved in the case we'll be discussing, Gunn v. Minton. Jane Webre represented, successfully I might add, the petitioner attorneys in this case. Jane is a partner at Scott, Douglas, and McConaughey in Austin, and her practice focuses on civil appellate law. She's argued appeals in the U.S. Supreme Court, as well as the Fifth Circuit, the Texas Supreme Court, and other Texas appellate courts. She's also a frequent speaker at seminars on issues of appellate civil procedure. Jane received both her undergrad and law degrees from the University of Texas, and following graduation, she clerked for Judge Garza on the Fifth Circuit. Ronald Mallen is a nationally recognized expert on issues of lawyer professional liability and risk management. He is a partner with Henshaw and Culbertson in San Francisco, and he has practiced in this area for over 40 years. Drawing from that experience, he submitted an amicus brief in this case, Gunn v. Minton. Ron has been the co-author of the leading treatise on lawyer professional liability since 1977, which is the 5-volume work, Legal Malpractice. And he's authored more than 100 articles on related topics. He's also chaired the ABA's Standing Committee on Lawyers' Professional Liability. Ron earned a bachelor's from Stanford and a JD from the University of California, Hastings College of Law. Welcome. So we'll begin this panel. I will briefly recap what this case is about. So in Gunn v. Minton, the Supreme Court unanimously held that state law malpractice claims based on acts in prior patent cases may be heard in state court. More specifically, it held that these kinds of claims are not excluded from state court, despite this federal statute that provides for exclusive federal jurisdiction over any case, and I'm quoting, arising under any act of Congress relating to patents. To reach its decision, the court held that federal jurisdiction is exclusive only where the underlying patent issue satisfies the 4-part Grable test. That test is the federal issue must be A, necessarily raised, B, actually disputed, C, substantial, and D, capable of resolution in a federal court without disrupting the federal-state balance approved by Congress. Now, in this particular case, Minton had argued that his prior lease of his patent was an experimental use that did not invalidate it. This was an argument that his lawyers in the patent infringement case had waived. He sued, and the court held that the patent issue was A, necessarily raised in the malpractice action, and B, actually disputed. However, it was not C, substantial, in its importance to the federal system as a whole. No matter how the state court resolved this experimental use question, it would simply not change the real-world result of the prior infringement action, which was that Minton's patent was invalid. Okay, so with that introduction, let's just launch into some questions. So this ruling raises quite a few. And the first one, and one that is definitely on a lot of patent lawyers' minds, is what impact will this decision have on other state law claims that involve this embedded patent question? So for instance, breach of contract cases, business disparagement cases. Jane, what do you have to say about that?
I anticipate that on a going forward basis, more state law claims relating to with embedded patent issues will remain in state court than before. I think that legal malpractice cases will all be back in state court, but other state law cases will, more than before, remain in state court, and here's why. The Federal Circuit had, I've got to back up a little bit in the jurisprudence. In 1988, the U.S. Supreme Court decided a case called Christensen. And it was actually one that had, its procedural history was it bounced back and forth between the Federal Circuit and the Seventh Circuit. No, after you, Alphonse, after you, Garcon, they went like this back and forth for a while, and finally the Supreme Court stepped in and said, ya basta, and articulated a rule of how do you decide which embedded question, the scope of Federal Circuit appellate jurisdiction. And that case did a couple of things. One is it established the premise that the subject matter jurisdiction embedded question 1331 should be construed consistent with 1338 in patent cases and in all other federal question cases. That is, patents aren't magic is sort of the jurisdictional concept that came out of the Christensen case. You still look at, is this truly arising under? You don't say, oh, it smells like a patent, let's bring it up to the Federal Circuit's appellate jurisdiction. So the Christensen case established that for linguistic consistency, 1331 and 1338 are the same thing, but then they had put in a sound bite in articulating the test of how to decide when an embedded question, state law embedded question case ought to belong in federal court. They said it needs to be substantial in that, the federal question needs to be substantial in that it is a necessary element of the well-pleaded claims. And that soundbite conflated necessity and substantiality. And then Katie barred the door. So from thereafter, the Federal Circuit, since 1988 in the Christensen case, the Federal Circuit has been construing and analyzing its jurisdiction for embedded question cases with that yardstick in mind. Is the patent law question a necessary element of the well-pleaded claim? And what the Supreme Court did in the Gunn case is say, ixnay, necessary element, that's the necessity prong. Substantiality is different. And we're going to weigh that and measure that in terms of the interest, not of these litigants and the necessity to this particular cause of action, but to the interest of the federal government as a whole. And so for legal malpractice cases, we asked the court to make a bright line rule and say never, ever, ever, not ever can those belong in the exclusive jurisdiction of the federal courts because of the hypothetical nature, and I think Ron's going to talk about that in a bit. But the court couldn't quite get there. They said rarely, if ever, but I think we're going to find never. But for other state law claims like breach of contract, business disparagement, injurious falsehood, business torts, the sort of state law claims that a lot of times were meat and potatoes, embedded question jurisdiction in the federal courts, I think a lot of those are now going to scooch to state court. And in fact, the Federal Circuit, I've only found one Federal Circuit case post-Gunn analyzing the jurisdictional question, and that's a case called Forrester versus Webre, decided in May of this year, and the court sent it back to state court and analyzed, tracked through its jurisdiction, tracked through, we used to take hold of all of these, and before Gunn, we'd have taken hold of this one, but now we're going to analyze it differently. So I think you're going to see more state law embedded question cases back into state court rather than the sort of hair trigger that we saw pre-Gunn.
Ron, would you like to add anything?
No, I think Jane did a great job on that. I don't know if you have a question, but I sort of have a comment.
Okay.
When people find out that my practice is really only representation of lawyers, they say, well, tell me about your cases. And I say, in how many areas do lawyers practice? So the exciting thing for me about my practice is I am involved in every area of law that lawyers practice, whether it's patent law, administrative law. And so when I traced this case that was coming out, cases out of the Federal Circuit, these wise judges who've been congressionally appointed, trained as district court judges, elevated to the courts of appeal, I kind of kept shaking my head. How can I be brain dead and not understand why this particular form of a legal malpractice case, where the issue involved is the question of did the lawyer make an error? Would the patent have issued going to causation of damages? How can that be different than any other case I look at where the error is the lawyer failed to perfect an appeal, and we have some trial judge who's not bright enough to ever make it to a court of appeal, deciding what a court of appeal would have done. So this was a hot topic in our field for a long, long time, because the Federal Circuit is correct on a hypothetical basis. These are really complicated issues that trial judges know nothing about in state courts. They really are material and substantial, but only in a hypothetical context. I just wanted to give that foundation, Christi, so
Okay, thank you.
deal with questions from here on out.
Okay. So another question that surely is on patent lawyers' minds and malpractice lawyers' minds is what's going to happen to the cases that are currently pending? So those that are in federal court solely on the basis of arising under jurisdiction. What's going to happen to these malpractice actions that have been concluded and are pending on appeal, that have already concluded following appeal? So Ron, I'd like to start with you. What is your best prediction based on your many years of experience?
Well, I know it's many years of experience, starting from the premise that a court without jurisdiction has no jurisdiction. There is in the materials you have, and I put together a list of cases as of the time of what's going to happen. And this is something I'm going to be tracking for several years because it's not reaching fruition. What you will see there are cases that were removed from state court are kicked back to state court. Cases that were filed originally under subject matter jurisdiction are being dismissed and sometimes directed back to state court. Which court? We don't know. On the cases that were filed and being dealt with, and considering how slow the court's calendars are in getting to these, there's going to be a lot more dismissals. Now, this is a jurisdiction-specific question. Does being in a court, a federal court here, without jurisdiction, toll the state statute of limitations? There is, and it's almost anecdotal because it's not a published decision, it was a news report about, in California, a case that was dismissed not because Gunn had come down, but because it didn't meet the federal circuit's standards on substantiality. So the case was dismissed, remanded back to state court from where it had come, and the trial court ruled the statute had run because there was no tolling. Now, some states have tolling provisions. There is one case, a published case out of Texas, that was dismissed for the same reason, went back to state court. The party said, well, here are the rulings that were made in the federal court. We'd like this court to adopt them. And the court said, you just gave me a case where the court had no jurisdiction. Whatever the court did is a nullity. Now, you've got cases on appeal. I haven't seen any dismissed yet, but how can you have an appeal on a case where the court had no jurisdiction? And to take it a step further, and I don't know what's happening here, what about the judgments that were rendered by a court that didn't have jurisdiction to render a judgment? Can they be enforced? Probably not. But what about the judgments that were collected? Can you get your money back? This is why legal malpractice is kind of fun. It takes you into hypothetical beyond hypothetical. So the answer is, if I were back here next year, I can give you a more complete update. But you have the universe of decisions I can find, none of which are really published. They're off of Westlaw. So that's a cryptic answer to a cryptic question.
Okay. Jane, would you like to add anything?
Just if you look at the procedural history of our case, of the Minton case, is sort of a perfect poster child of why it's important to get jurisdiction right. Uncertainty is everybody's enemy. Mr. Minton filed his legal malpractice claims. There was an underlying case in federal court, a real patent case of Mr. Minton versus the NASDAQ. He sued the NASDAQ saying, you owe me for every online trade you've ever made because of this software that I have patented. And the NASDAQ won in federal court in a real patent case. The NASDAQ won a take-nothing summary judgment, and that was affirmed on appeal by the Federal Circuit, and then that was cert denied. Done. So he then sued his lawyers in state court on a negligence theory, legal malpractice, saying, you didn't raise the experimental use exception to the on-sale bar, which was the grounds for the summary judgment in the real patent case. And there was a summary we litigated. He filed it in state court. We litigated it in state court. My firm represented the lawyer defendants in the state court, and we won a summary judgment that even if we'd have raised it, it would not have prevailed because it was not a valid, it didn't apply. There was no experimental use. So we won a summary judgment on the merits, and then it went up to the Intermediate State Court of Appeals. And while it was pending there at the Intermediate State Court of Appeals, the Federal Circuit decided a pair of cases, error measurement and immunocept, where it first glommed hold of legal malpractice cases and said they come within this exclusive jurisdiction. So at that point, we've been litigating for several years in state court where Mr. Minton filed. We have a final judgment. We're already on appeal, and so for the first time, we fight jurisdiction at the Intermediate Court of Appeals. And I wrote this brief. I argued in the Court of Appeals, saying no thank you to the Federal Circuit. You don't have to follow them, Texas Intermediate Court of Appeals, and they got it wrong. They went too far on the 1338, 1331 issue, and say no thank you. And the court agreed with me, and they said Federal Circuit got it wrong, we have jurisdiction, and then they affirmed on the merits the summary judgment. Then it went to the Supreme Court of Texas, which went the other way, said Federal Circuit's right, split decision of the court, 5-3, and then they said state courts have no jurisdiction, dismissed for want of jurisdiction, and at that point, Mr. Minton did what a lot of, Texas has a savings clause, and he refiled his claims from scratch in federal court in Texas. So we were at that point beginning with plaintiff's original complaint, which was verbatim plaintiff's original petition filed 6 years earlier in state court. Fortunately for us, we filed our cert petition, it was granted, the court reversed and said, yes, state courts do, and so then at that point, the brand new federal action, legal malpractice action, never went forward. It was dismissed at the district court level. But if we had not gotten that relief on certiorari, we would have been litigating the second time around, and nothing we did before, the 6 years of litigation and the millions of dollars, nothing, nullity. And so that's why it is so important that we know and that there be firm lines of where you belong, so you don't end up in a double litigation.
Okay, so to take a step back, so one way to look at this decision is that the U.S. Supreme Court has finally found a way for state courts to be involved in patent cases. And the question is it good for the patent system for state courts to participate in the resolution of patent issues, even if it's a hypothetical resolution? And going even further, should state courts' participation be even broader, which is something that it looks like Judge Diane Wood will be advocating in a few hours.
Well, put it in context. What influence is a trial court's instruction to a jury that comes out with a verdict for money going to have upon anything in the world? So the answer is nothing. It's now, you can go up to a court of appeal and maybe you get a published decision or an unpublished decision, then it may have some influence. But the focus of your question implies that there's something unique and special about an area in patent law, as distinguished from antitrust law, as distinguished from appellate law, as distinguished from any other area. And the answer is no. If you take the pragmatic approach, the Federal Circuit is right. Patent law issues are best handled by that branch of our judiciary best equipped to decide them. But that's not the issue. The issue is, do we take a legal malpractice case where the issue concerns the extent of damages, the fact of damages, or the issue of fault, and somehow say the concept of patent law is so significant that it supersedes common law in every jurisdiction in the United States? And the answer to it is no. So will it have impact? You still have diversity cases, federal diversity cases. You have diversity jurisdictions. So there you go, you're before a federal judge. It's important to know the diversity of interests going into the Supreme Court decision and my agreeing to do an amicus. I had to do the amicus in my name as an author, not in the firm's name, because our law firm clients want to be in federal court. They want a federal judge to decide it. So the position I was taking was antithetical to what our clients wanted to have. They wanted to get that benefit. Yeah, it is a conundrum because how are trial court judges who don't even know what a patent is going to figure out what to do? But it's no different than any other area of legal malpractice law. And believe me, having been doing this for over 40 years, a lot of state court judges don't even know how to handle a legal malpractice case. And if you gave them a legal malpractice case with a complex patent issue, they'll probably find an excuse to pass it off to some other judge.
I want to make 2 points. One is, well, 3, I guess. I want to quibble with the characterization that the Supreme Court has found a way for state courts to hear more patent issues, because the U.S. Supreme Court has been consistent on this going back to Christensen. 1331 and 1338 mean the same thing. Linguistic consistency arising under means, those words mean the same thing in every context, and there isn't a magical, but this is a patent, it's different because the words are the same. Congress has drawn that line. In the Holmes Group versus Vornado case in 2002, the court said, a counterclaim doesn't get you there because the well-pleaded complaint doesn't look at counterclaims. It is the plaintiff is the master of his destiny. And just because it's patent, we're not going to treat it differently. I think Justice Scalia wrote the opinion and said it would be an act of necromancy or something to change the scope of that jurisdiction. But going to is this a good thing for patent law to have state courts pipe up? I think there are 2 points to think about that. One is, if you go back in time to the early years, the time of the creation of the Federal Circuit and the early years of its jurisprudence, when this is a new animal. We never had this before. What does it mean? Well, when Congress created the Federal Circuit and when the Federal Circuit in its early years discussed its own jurisdiction, nobody had in mind that this would be a walled-off area where only this Star Chamber could decide these cases. The Federal Circuit didn't have such an expansive view of its own jurisdiction, and if you look back in an early case in the very early 80s, an opinion written by the first Chief Justice of the court, Chief Justice Markey, who was responsible for a whole lot of the laying the ground rules. He was sort of the John Marshall of the Federal Circuit. And Chief Justice Markey wrote in a case called Atari versus JS&A Group, Congress was not concerned that an occasional patent law decision of a regional circuit court or of a state court would defeat its goal of increased uniformity in the national law of patents. That was in 1984. And then you fast forward, and the Federal Circuit of 2010 has a very different view of its jurisdiction. But when it was invented, nobody thought that it was going to be, no one anticipated or thought it was important to have it be so, if it smells like a patent, it's got to be decided here. And in fact, if you look at some of the legislative history and discussion at the time, secondary sources talk about how it's a good and healthy thing to have voices from outside, to avoid creating an echo chamber. That's a good thing. And my second point is, we're not going to screw it up. The state courts are not going to screw it up for the real patent cases. if they decide, if a state court decides a patent issue attendant to a breach of contract or a legal malpractice case or whatever, first of all, that's not binding on any federal court. So you can tell your federal district court in the Eastern District of Texas, where all y'all come, and you can tell them, no, you don't need to listen to the Supreme Court of Nebraska in its discussion in the new tech cases regarding this patent issue. Look at the federal circuits. Precedent. But also look at the new tech case. There's a pair of cases out of Nebraska. Nebraska decided the legal malpractice cases arising out of patent, and the state, this was before the federal circuit had decided the air measurement case. And so the Nebraska courts did what courts are supposed to do. This case was filed in my court. I'm going to roll up my sleeves and take care of whatever has to happen. And that state district court had a Markman hearing, and that went up on appeal, and then they tried the merits of the case, and those courts, they handled it, and the sky didn't fall. And those new tech cases have been cited a gajillion times for the jurisdictional issue until Gunn resolved this. They've been cited a jillion times for that jurisdiction issue, but they've been cited exactly 0 times for the substantive patent law issue. So it's not going to mess with y'all. It's not going to disturb your jurisprudence. But if it turns out that somebody out there has a state district court, a state appellate court, looks at something in a different way, and you bring that not as binding authority, but as, look, here's another way of looking at it, and it contributes to the jurisprudence, then more power to them.
Okay, a lot of good stuff here. I want to follow up on a few things, time permitting. Okay, so first of all, Jane, state courts are not going to screw things up. So why are so many attorneys scared of this, as suggested by some of the literature and commentary out there?
She didn't say they're not going to screw it up. She says it's not going to be binding.
It's not going to be binding.
They can screw it up.
It's not going to screw up the. I mean, every one of us can point to some case that we read or some case that we've handled and said, man, that court got that one wrong. Getting an individual case wrong is different from screwing up the jurisprudence. Yeah. I think we can all agree on that. But there's no reason to be afraid of state court. There's no reason to be afraid of state court. If patent lawyers are afraid of state court, it is a question of familiarity because real patent cases are in federal court, and that's probably where most of y'all have your comfort level. But state courts, Ron tries cases in state court, I try cases in state court, all God's children try cases in state court. And there are good state judges, there are bad state judges, there are good federal judges, there are bad federal judges. There's nothing inherently, there's no inherent incompetence in the state systems. And the fact is that if Congress had wanted to make it different, they could have done so when they created the Federal Circuit. They could have done so 2 years ago with the America Invents Act. They did not change the 1331, 1338 linguistic consistency. And although they reached out and grabbed compulsory counterclaims, they did not grab patent issues as permissive counterclaims, patent issues as defensive matters. So Congress looked at this, and there was a whole lot in the American Invents Act, a whole lot of discussion. No, we need to have this all come in. And Congress drew that line, and there it is. And there is nothing to be afraid of. Come on over to the state system.
Rod, do you want to add anything?
No, I just keep going back and say, put this in perspective. It's a patent law issue, it's an intellectual property issue, it's an antitrust issue, it's a RICO issue, they screwed up a RICO suit. I mean, you go down the list, and that's in the slides you'll see a picture of Alice going into the looking glass. She's going into legal malpractice land. She comes out of the looking glass. She is now in legal malpractice land. We're a hypothetical world. We're deciding issues, some of very great significance, by a trial judge who's maybe just been appointed to the bench. And is that going to have precedent in any sense of the way? Not at the trial court level. From my knowledge, I think the only trial court opinions I see published, well, New York publishes everything, although they're now starting not to publish. You've got Connecticut, maybe Vermont, but you'll never read a trial court decision out of California. So what are we concerned about? If you're looking at influence, the appellate level, but does it mean that the patent law issue is going to go to the appellate level? Maybe. Or, the Texas Supreme Court. And as an aside, I really don't understand why the U.S. Supreme Court, with all of these Federal Circuit cases and people seeking review, pick on our Texas decision, a state court decision that it just, anyway.
Well, I personally am super glad that they picked the Gunn case as the vehicle and not one of the umpteen presented to them at the same time. At the same conference, they had before them, they picked between three vehicles to decide this issue, one of which was a Federal Circuit en banc decision, the Byrne case, where the Federal Circuit split on the legal malpractice jurisdiction issue. And I'm glad they picked mine, and I think they picked ours just because it presented the legal issue in a clean way. I don't think there was anything magical about the fact that it came from a state court.
No, I mean, what stretches my imagination here is one of the questions where the Supreme Court said, we're not saying that there can never be a patent law issue that wouldn't invoke jurisdiction. But what they didn't say is we can't think of any. I put that around my head so many times. I can't think of a legal malpractice, forget other areas of the law in my field, legal malpractice case involving a patent issue that would ever invoke federal subject matter jurisdiction. It just doesn't happen in my field. So with that around, I think, I don't put in context. Legal malpractice issues, state court, federal on diversity. You got diversity, you can get yourself a real federal judge. You don't have diversity, can you make references? Sometimes a trial court, a federal court will shoot over to a state Supreme Court a question they want certified. But I've not seen it going the other way. I've not seen a trial court, for example, send a question to a federal district court, please help me out with patent law issues. It doesn't happen.
So that was a question I had, is it that the court did kind of open the door to, well, it's possible, and whether there was any circumstance you could think of.
They were being perfect. They were saying there may be a possibility, so they didn't make a stupid remark. But I've talked to no one who can give me an answer to when a legal malpractice issue, which is error, the fact of damages, or the amount of damages, would invoke patent law jurisdiction.
And that was the subject of a whole lot of briefing by the parties and a whole lot of our argument. And the reason that the legal malpractice cases don't present a substantial issue is because of the hypothetical nature. Like in our case, Mr. Minton's patent was invalidated in the underlying real patent case. The federal district court in the Eastern District of Texas, affirmed by the Federal Circuit, cert denied, declared his patent invalid in the Minton versus NASDAQ case. And that is irrevocable. It is written in stone. It can't ever be undone, no matter what happens in the subsequent legal malpractice case. Even if there's a judgment in the legal malpractice case that it was only invalidated because the lawyer screwed up, because in fact the experimental use exception was valid and it was their error, their professional negligence that resulted in it, and he would have won and he would have gotten $1 bajillion from the NASDAQ, that's never going to resuscitate his patent, which is irrevocably dead. And that's the inherent nature of the hypothetical. And we went through a whole lot of, and would that be binding on the PTO? No, they're not a party. Would it be binding on the federal courts in future malpractice cases, in future real patent cases, because if they construe a patent? No, federal courts aren't bound by state courts on issues of federal law. So that's why we asked for a bright line rule. Just say it. just say it and give us the certainty. But the court couldn't get there. But they came so they said rarely, if ever.
You got 99.5%. Okay.
So I was happy about that. But that's why from a jurisprudence standpoint, these aren't going to mess with patent law.
So I have many other questions, but I'm going to stop myself now and ask if anyone in the audience in these last few minutes has a question. Mark?
Can you just bellow?
I can bellow. Believe me, I think they want the mic for recording purposes. So very interesting. Two questions. One has to do with the will it ever matter issue. And there it seems to me that, Jan, you're right, assuming that the patent has already been invalidated, which is going to be the normal run of cases. But not all IP malpractice cases are going to take that form. Right? They might be cases in which the malpractice claim is filed against the underlying defendant for failing to defeat a patent on some ground, or there might be cases in which the patent claim was narrowed but not invalidated. And in those cases, you can imagine the defense of the lawyer being, this patent is in fact invalid, and a district court or a trial court having to make a determination, this patent is in fact invalid or not. Now that determination, I think, if the patentee is a party, ought to bind that patentee for all successive litigation. So I don't know that it's exactly right to say that it can never have an effect on substantive patent law, because you might end up having a substantive ruling that this patent is invalid, and then we have to decide whether to treat that as kind of irrelevant to the actual validity of the patent because it occurred in state court or not.
Well, I think that there are several steps to your question. One is that kind of scenario may be why they said the rarely, if ever. That's the 0.5% that maybe somewhere there's a hypothetical you could come up with. If you stood on one foot and it's a leap year and the moon is in the 7th house, we could find an instance where that could happen. But more important, even if you could paint a scenario where there could be an impact vis-a-vis some live patent rights. That doesn't ipso facto, or as Tigger would say, ipso fatso, bring you within arising under jurisdiction, and here's why. You're conflating, again, necessity and substantiality, because just because there may be a construction of a live patent, as you might find, for example, in a breach of contract case, or business disparagement or whatever, doesn't necessarily make it a substantial issue in the eyes of the federal government as a whole. It's not a substantial issue to the federal government as a whole. There's not a hair trigger on jurisdiction any longer. If the construction of that patent in your scenario doesn't involve a novel issue of an unsettled issue of law, if it's just a question of applying facts, the unique facts, the fact-bound and situation-specific is the standard that the Supreme Court has articulated, then it doesn't trigger federal court jurisdiction, even if in fact it's going to impact a patent.
There's a shorter answer, though. The judgment by the court is not going to be that the patent is invalid. It's going to be a defense judgment for the lawyer. And that is what carries the legal precedent. All this other muckety-muck stuff about patents in between, it doesn't go anyplace. It either goes to the issue of the amount of damages, the fact of error, the fact of damage. So everything results, in my hypothetical world, in a judgment for one party or another in a certain amount. So it still remains hypothetical, but your point brings it closer intellectually. It's like sitting around with you guys at dinner listening to stuff about counterfeiting. It was giving me a headache. I couldn't quite figure out what we're talking about, but it's the same type situation. What you guys got to do is say, we're in Alice in Wonderland, and the only result is who wins, who loses, and for how much.
Second question, briefly. state courts are presumably less familiar than federal judges with patent cases. So it seems logical to me that one impact of moving these cases from federal to state court is that the state courts are going to be more reluctant to second guess the decision of the lawyer because they don't know the intricacies of patent law to the same extent. Now, leave aside the jurisdictional question, it may be required, but I guess I wonder whether you think an effect of this decision is state judges are going to be more reluctant to decide that the attorney did something wrong here.
No, the state judges are going to do what judges do, which is roll up your sleeves and take care of the case that's in front of you. Look at the intermediate Texas State Court of Appeals decision in the Minton versus Gunn versus Minton case. What they did was they looked at federal circuit precedent, because that's what binds, and they analyzed the issue before them, just like they analyze oil and gas cases and whatever, breach of contract cases, this case, that case. They decide the legal issue presented to them. They look to the relevant precedent, and our clients wish that the judges would just defer to the decisions that the clients made in the underlying cases, but that is emphatically not true.
But the point I was making before, law firms are much more comfortable having a federal judge decide the patent law issues. And as I said, in my experience, and I've tried like 70 cases, I get into a court, half the time the judge knows nothing about legal malpractice law, which is even more scary than I was dealing with a patent law issue. So the fear is that the judge, a state court judge, will not understand patent law and come out with a result that's going to be askew. But that's true in any underlying case.
And we are out of time. I know there were other hands raised in the audience. I encourage you to find Jane and Ron offline and ask them your questions, but we've got to hand it over to the next panel. Thank you so much.